Okay, so it's 2 o'clock on my clock, so I am going to get started. Again, welcome to our webinar today. Thank you for being here. My name is Giselle Carson. I am a business immigration attorney, and I am going to be talking to you about the H-1B cap. Another unique year, and some of you on the call are employers of those that have not been selected, were not selected for this year's cap. And some of you are foreign nationals that were not selected and are looking at options to consider. Want to let you know that this is for you. So one, thank you to many of you that when you register, send me questions. I will incorporate the answers to those questions as part of the webinar. So I made some edits yesterday to include your questions. So again, thank you. I also want to encourage you to participate. Again, this is for you. So use the chat box to send me your comments, your questions. Ellen, who is an immigration paralegal with our team, is also helping manage the chat. So she's already there and she said, welcome to you all. The webinar is going to be about an hour. So we're going to try to pack in a lot of information. Know that this is an overview of the options available. And for those of you that are on the call that are our clients with the HR teams, and the foreign nationals, we are going to have follow-up individual appointments or individual calls with each one of you to explore your particular situation. But again, this should provide you with an overview to start thinking things that you may not have considered or things that you are considering that may not be exactly as you're thinking. So that's what this is. That's what this will provide. Again, feel free to be engaged. It makes it a lot more interesting for you and for us. So I have one question on the chat. I would like to know what options an employee has if they were not selected in the H-1B cap lottery for the third time and their current H-1B expires summer of 2021. Well, let me just go right into the next slide. And this slide is going to kind of tell you the things that we're going to be talking about and the main options for everybody. Not to say that there are others. Every year I discover a new option for somebody as we've been doing this. But here are the main options to think about. So my first slide is going to be options beyond the H-1B, and you'll see a very general overview of all the options there. Then I'm going to explore in a little bit more detail the F1 situation, the CPT STEM, because as we looked at our client base, and many of you are foreign nationals in F1 status that are ending their STEM or ending their OPT and are looking for options. So I'll talk about those in detail. Then I'll explore some of the other options: marriage to USC, employment authorization documents that it's dependent on a spouse, working overseas. Some of our clients are global companies that have offices abroad. And every year that is an option that should be considered if possible. EB, the employment-based green card, I've gotten various questions about that. And it is a complex, long process, always an option, but you should have an underlying status. And again, I'll cover that. I have received a question about an O1, so I've included that. Returning to home country, and the question in everybody's mind, will there be a second lottery? But I wanted to cover that at the end because I do believe that all of these options need to be on the table. Okay, everybody, how are we doing so far? Again, this is your chance to work those fingers and let me know that you can hear me, that everybody's doing well. Awesome, thank you. Okay, so actually, before I'm going to my beautiful star that's coming up, or all the pedicles that you'll see next, I couldn't be doing this without the amazing team that I have here. Many of you that work with them, and sometimes you have never seen them in person. So I thought that it's a good idea to see them. So here's our core team. We have various other people that work at the firm and make it all work. For immigration, we have Tyra and Ellen and Danielis and myself. And again, very grateful to them that bring their passion, energy, and determination every day to work, to do what we do for our clients and to help you achieve your goals. So here are the options beyond the H-1B in a, again, very broad perspective. P1s for athletes, national interest waiver, which is an option for a green card, very, very narrow niche if your work is in the national interest of the US, very high standard. Green card marriage base, TN is a professional visa for those that are from Canada or Mexico. O1 extraordinary ability, L1 intra-company transfer for those of you that have the option to transfer abroad and work from abroad and then come back to the United States. EB1 green card category at the highest level, extraordinary ability. H-1B concurrent employment, we have done those a few times. F1 CPT, STEM OPT, the green card path through employment base, E3, professional from Australia. Again, very broad, and there's more, but this is in general what we kind of tend to see and explore with clients. So for those that are ending, that they don't have a clear path, these are many options to explore. Here is my first slide relating to the students on F1, and frankly, this is I have 3 slides, I believe now, after I edited the presentation yesterday, relating to F1. So this one, it has everything here. So kind of pay attention. The things that, and primarily this slide, I put it here mostly for employers. Because the foreign nationals that we work with, they get this information in school. They know it pretty well. For our HR professionals, they have a lot going on, and this is just a little portion of their day. So I am going to review the F1 situations and options. So CPT, get a lot of questions about that. Only while the foreign national is enrolled in school. That's when CPT happens, between 1 to 20 hours a week during the academic semester, and then 20 or more during the summer breaks or during the breaks. Now, this is important. It's authorized by the school each term. So there is a significant amount of paperwork and things that need to happen with CPT. So it's not something that you get for a year like OPT or 2 or 3 years like a STEM. Or it's authorized by the school each semester. Every school has their own little version as to how you can get into STEM OPT. So it doesn't apply the same for everybody in some ways. So it's very, very case specific. But it's an option that many of the foreign nationals use to continue to study and also get training and work while they're continuing to explore options. Then the OPT, as many of you have probably experienced that have been on F1 and then obtained their EAD. Many of you are there now. And then, so I'm not going to cover it in a lot of detail, but then there's the STEM OPT. So quite a few of you were an OPT and have the opportunity to go through a STEM OPT. And I get asked many times, should I apply should I apply for a STEM OPT? And to me, a STEM OPT, if you're entitled or if you can apply for it, is something that you should do. because it provides a significant amount of benefits. Again, overview of STEM, only for designated US STEM majors, only use after post OPT, so you cannot just jump from CPT to STEM, authorized by USCIS. Now this is, and actually I think I have a slide about this before, but the EAD card with the STEM OPT, because again, that is, to me, is a huge gift. So I have it in a different slide. Training program, so there is an additional process or requirements that come with the STEM OPT. Is this I-983 that needs to be completed by the employer and the foreign national, and it has their own requirements. And the employer needs to be enrolled in E-Verify. And I believe Ellen summarized those options out there. Questions so far on this? Okay, so I'm going to go into a little bit more detail as to how this may affect each one of you. So again, CPT, the authorization comes from the school. So if a student, if one student wants to continue to utilize the CPT option, it is going back to their DSO and exploring the option for CPT. It takes about a few days to process the authorization. There is no fee for the CPT, but there is a registration to be paid. There is a limit as to how many times the person can use CPT. So some foreign nationals kind of go into CPT for extended periods of time just because they're waiting for that H-1B to come around. We have to thread on that carefully because not CBP, but USCIS could be seeing it not as a training opportunity, but as a work opportunity. Again, for each of you that are affected by this, we will individually strategize about it, but just know that if you're on CPT for a very long time and there is no, I cannot tell you 2 years, 3 years, 6 months, what is a very long time. It's very kind of case specific, but just be careful with too much CPT. So this is the other piece with CPT. Again, there is flexibility with the schools and how they provide it. And some schools do not allow CPT during their first year. So you have to have one full academic year before the person can use CPT. So that is important to know. And you need a job offer to support the CPT application. Next slide is about STEM. And this is the main reason I put the slide here is if some of you are looking to apply for STEM, or some of you employers have foreign nationals that are looking into the STEM OPT application to obtain the EAD to continue to be work authorized. I don't know about you, but I have noticed that the mail, the US mail in all fashions, FedEx, USPS, everything is not as reliable and is not as fast as it used to be. I had a FedEx that was supposed to, we send it to Orlando, and Orlando was supposed to send it to us, a client. It went all the way to Seattle, from Jacksonville to Seattle, Seattle to Orlando, Orlando to Seattle, Seattle, Jacksonville. I have no idea how that happened, but that's what happened to a FedEx, which to us is pretty reliable, and we pay the tracking. And anyway, long story, every year I hear of foreign nationals that they did everything right except for they waited until the last week to put their EAD application in the mail, and it gets to USCIS beyond the filing deadline. They miss that opportunity. STEM is denied. Please, 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 if you're in this situation, employers, if you have foreign nationals that are going to take the advantage of this amazing opportunity, make sure, and again, it's not on the employers, it's you foreign nationals for wait until the last minute for whatever reason. This is your work. This is your life. This is your work opportunity for the next few years. Do not wait until the last minute to put it in the mail. or you will regret it for a very long time if this is your option. So make sure that you get it in the mail on time. The next thing that is to me is a huge bonus for STEM is that once that application for employment authorization is filed and pending with USCIS, even though it hasn't been approved, which it may take, who knows, these days it may take 200 days before it gets approved. No, actually, hopefully not 200 days, because what happens, so maybe 100 days. You get an automatic extension. You, the foreign national, gets an automatic extension of their work authorization once that STEM OPT EAD has been filed and accepted by USCIS. So once you get your receipt notice back, that's what you could use to provide your employer as evidence of your ongoing employment authorization for I-9 verification purposes. And you have this automatic work extension, which is wonderful. I have clients now on H-4 extensions that have been waiting for months, and they can get an extension. So this is huge benefit. So that's I believe the general gist of what I kind of have to say on STEM CPT. And I'm going to move on to okay, and Ellen, thank you for kind of clarifying some of the stuff on the chat that I'm talking about here. So the next one that I'm going to talk about is marriage to U.S. citizen. Almost every year, at least 3, 4, 5 foreign nationals take this option. First, I have to say it needs to be for love and not in order to obtain immigration status or work authorization. Obviously, no one wants to get married and be married to somebody that they are not in love with, but many of you foreign nationals are, you're your prime of, at the age where you're dating and you have fiancés and you're looking to marry. And, here it is that you were not selected for the H-1B. I mean, I was one of those that, as an immigrant myself, I wanted to make my own path to a green card and to naturalization without, being married to somebody. But, and I, my husband was also a foreigner. And so we kind of forged our path to our green cards by working and getting there. But for some of you, you're going to get married to the love of your life, who is a U.S. citizen. And, maybe the wedding is planned for December. And if when we talk to you, if this is in your plan, I do want you to talk to us about it so that we can explore the possibilities there. Again, if it's not on your plan, please do not go out trying to find a fiance because of what I'm saying here. But if it is in your plans, it is something to consider. And I want you to know, and this is why I'm putting these flow charts here, it is a process. It is not that you get married, you file, and you get an employment authorization document. So if I know that the flow chart is long, but if you go to the first square box on the second row, that's the one that says receive EAD, employment authorization document. So there's a long way before you get there. Again, we had several clients last year that went through this process. They're going through the process right now. In fact, one of them, as I speak, had the opportunity to also apply for STEM EAD. So he is covered with his STEM OPT, and he got his EAD based on the STEM OPT, and he's working with that. Concurrently, we filed the marriage-based petition for him, and he's still waiting for his EAD based on the marriage to a U.S. citizen, the I-485 EAD. It has not arrived, and thankfully, he did apply for his STEM. He did get the STEM EAD, and that is what he has lost no work authorization. He's continuing to work, but not because of the marriage to a U.S. citizen EAD, but because of his STEM EAD. So it is definitely an option, but it's not going to happen overnight. The other thing that I want to say to you Some of you may fall out of a status because your F1 status ends, or your H4 status ends, or whatever it is that you're on. Marriage to U.S. citizens provides a semi-waiver to this unlawful presence, if you want to call it that, where you're kind of waiting for the marriage petition to be adjudicated and whatnot. So there are benefits there. Again, take it with a grain of salt. It's not for everybody. And again, most of what I'm going to talk about is certainly not for everybody. Every option is just things for you to consider. Okay, so on the same vein of kind of, looking at the spouse, a fiance, the relationship to somebody else in your family. There are some visas that come with the ability for the dependent spouse to apply for work authorization. It's the limited amount of visas, but here are some of them. One of them is the L1. So if your spouse, for some reason, is an L1 beneficiary, an L1 principal, they're here in the United States because they, intra-company transferee, and you're an L2 status, that L2 is eligible to apply for EAD. So that will, again, this EAD applications, once you file them for all of this in this slide, it takes a while. It's not going to happen overnight, but it's an option. So L2s can apply for employment authorization. E2s, which are investors visas, can apply for employment authorizations. E3 spouses that are professionals from Australia can apply for employment authorization. And then I'm going to talk about the H4s and the asylum, because those are kind of unique in their own ways. H4. So if your principal, your spouse, is an H-1B beneficiary, certain H-4 spouses can apply for an employment authorization document, not all. What happened is many foreign nationals from India, China, and who those are that are waiting for years and years because of the priority dates to get a green card. So a few years back, a regulation was passed that said, if the only reason the H-4 cannot get work authorization is because their H-1B principal is waiting, actually that person, the H-1B principal, has a certified Perm application, so they have begun the green card process, and the only reason they have not gotten the green card is because of the priority days. So that H-1B principal has a labor certification that is approved, and I'm going to go through the employment-based green card next. So they have a Perm labor certification approved. They have an I-140 that has been approved. The only reason they cannot get an EAD is because of the priority dates. Then that H-4 spouse, with the evidence that I have talked about, can apply for an employment authorization document. And that is how can they get employment authorized. Now, I have a few H-4s right now that already have had their employment authorization documents, and they had applied to extend that employment authorization document. And the wait to get an extension is almost 6, 7, 8 months. So again, it's not an overnight thing, but for some of you that there is no other options, that this is definitely here. The other one is an asylum. Some of you on the call may be from Venezuela, or maybe from Nicaragua, or maybe from a country, or not necessarily country, maybe in a situation where asylum is an option. Now, I don't do asylum cases. My practice is business immigration cases, but there's many capable attorneys that specialize in asylum cases. And we have had cases where the foreign national spouse apply for asylum. The asylum petition has not been approved. They're just pending, and maybe it will never get approved. But for now, it's pending. And because of that, they're entitled to apply for an employment authorization document. And that employment authorization document has been issued. So that, again, is another option. Okay, let me just kind of check on the chat to see what we have here. quite a few things have happened since I last checked. Can you go into more detail regarding what differences are between an L2 and E2 and E3 and H4 and asylum? Well, the differences are, so these are all derivative or dependent visas. So they're dependent on someone else, the principal spouse. So the L2 is the spouse of an L1, an intercompany transferee. The E2 is an spouse of an E2. The E3 is an spouse of an E3. The H4 is an spouse of an H-1B. The asylum situation here is the spouse of an asylum. I'm not sure if that answers the question. So these are all people that are married to somebody else that has a different status, like I said, an L1, an H-1B, and that is what provides the opportunity to apply for an employment authorization document. Again, that relationship needs to be in existence, the proof of marriage needs to be, I mean, there's other stuff that needs to be filed, but that's what opens the door for this particular, for nationals to apply for the employment authorization. Hope that helps. For the H4 EAD, do we need our spouse? Yes. So, and that, how about the EAD as a dependent of an H-1B? Is that possible? I wish it was possible. So let me go back here because this can be confusing, or not confusing. I mean, it's just the way it is. So yes, for the H-4 spouse, in order for them to apply for an EAD, the I-140 petition for the principal for that H-1B would have to have been approved. Again, the only reason when the regulation passed, that was the reasoning. The only thing preventing that person from working is the fact that their priority day is so backlogged that they cannot get a green card. So, and there's, I want to say off the top of my head, there's about 100,000 Indian nationals primarily that are in that situation. And those are those H4s and those EADs. And yeah, there is no way to get a spouse H-1B if you're a spouse of an H-1B to get an EAD. This unique visas, it have been, lobbying, and who knows what goes behind. There is no rhyme or reason as to many things in immigration as to why the spouse of an L can get an employment authorization document and not the spouse of an H-1B. It all has to do with other powers beyond mine. Okay, so I am going to move on to the next slide because this one also, again, many questions about this. Well, let's start my green card process, because if I start my green card process, I'm going to be able to get an EAD. And that is true, but here is the green card process on an employment base. So the slide that you saw before with the U.S. marriage to a U.S. citizen is kind of the process to go from whatever status you're at, marriage to a U.S. citizen, all the way down to a green card. This is what the flow chart, the process would look like for an employment-based green card. So my employer feels, that they want to support my green card process, and this is the process that you have to go through. So the first part of the employment-based green card, and I have it divided into 3 phases. The first one is the labor certification, the Perm process. This process is taking about 1.5 years to 2 years to go from beginning to end. At the end of the step 1, you get a certification that basically says, not you, when I say you, in some ways, I'm saying that the certification belongs to the employer. The employer receives a certification that says you have complied, you have provided us evidence, you have complied with all of the requirements, you have shown us that you were not able to find a qualified U.S. worker to perform the duties of the position that you need someone for. And thus, as a result, we are going to grant you or certify this labor certification for you. So it will take at least, again, 2 years to get us there. The filing of the labor certification or even beginning the labor certification process does not provide any status whatsoever. So if all we do is begin this green card process for you and nothing else, you will fall out of status and you will not get a green card if you stay in the United States because you're not here lawfully present. So whenever I talk to foreign nationals about this, and they kind of forget that they, or don't know, that they have to have an underlying status. And that's why many times, even though let me just go through the whole process and then I'll go into my own little details in my head from the questions that I get. So first, again, step one, labor certification by the employer belongs to the employer. We get at the end of it a certification that says, okay, there is no qualified US workers. And again, we have to go to the market with the employer to recruit for a US worker to fill this position. And that requires strategy and patience and teamwork as part of this process. Because again, you're opening your position out and the foreign national could lose the whole process. So we are very cautious as we move through this process. And again, sometimes we just see the tree and not the forest. And our duty is to show you that there is a forest and we have to be careful. So we successfully completed step one. We move to step two. Step two is the immigrant petition. Again, this belongs to the employer. The employer files an immigrant petition with USCIS saying, so the first part of the process is through the Department of Labor. The second part of the process is through the USCIS. The employer files a petition with USCIS saying, I have tried to recruit for this position. No one applied or no one was qualified. The Department of Labor certified that I did everything that I need to do and I still have a position open. I would like to hire Ellen to fill that position. So here's my petition, USCIS, so that you grant me this immigrant visa for Ellen to fill the role of blah, blah, blah. I'm going to pay her blah, 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 da, 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 da. So that's the I-140 stage. The I-140 stage at this time can be premium process. So you could accelerate that process and, say you could get a response in 2 months. And I'm just, it could be, frankly, in reality, it's 15 days adjudication, but filing, mailing, whatever, say 2 months. But now we're stopped, particularly for many foreign nationals that are from India, from China, those that are the backlog with the priority dates. You can go no further. You're stopped. And now you still don't have an EAD. You may not have an underlying status. That's not a position you want to be in. So if you're not from a country that is backlogged or your priority day is current, which 2 years ago, EB1, which is the top category, was backlogged for almost a whole year. We couldn't even file a green card. So we were stopped at step two for executives, for extraordinary scientists. We were stopped at stage two. But let's say, being positive, the priority days is current and we can move forward. We can move on to step three. Step three is when now the foreign national comes into play. And now we go and talk to you about your immigration history, the fact that you're in status, the fact that you were legally admitted, the fact that you have all the requirements to meet the position, Your immigration history comes into play when we get to step three. And it is now that we file an application for employment authorization document for you. So know that at this point, we're potentially 2.5 years down the line. And this is when you can apply for an employment authorization document, which currently, even after filing, may take 100 to 120 days for you to receive. So yes, it is an option. Many times I get asked, well, should I just give up on the H-1B and just go through the green card process? And in the past, when we had a lot more certainty and the timelines were not as uncertain and all over the place as they are right now, we have done some, skipping the green card the H-1B lottery and going to the employment-based category. In today's immigration world, that is a very, very risky situation. I would want the foreign national to have an underlying status. And when I talk about an underlying status, through the whole process, all the way until they get to that green card, is they have an H-1B. And that's why we go through this H-1B process, because the H-1B gives you that platform to solidly bounce from and continue to work and go through this green card process. Again, this is driven by the employer, not the foreign national. So whatever that underlying status is, whether it's an F1, whether it's an H-1B, whether it's an O, whether it's a P, whether it's whatever, that alphabet, that is what gives you the platform, the foundation, the work authorization, the legal status to support an employment-based green card. An example from last year, actually, I'm going to take this example from the Asylum client. We went through the lottery, and they really, really were pushing for this employment-based green card. That's all they had in their mind. And I was like, look, we have to go through, we have to get you an underlying status before we jump into a green card. Because as you can see from going through this process, you're not going to get an employment authorization document until much, much, much later. And what are you going to do in between? So that is the importance of understanding the timelines and the options that you have, because it allows you to plan a little better. And when we start talking about your options, you can have a better understanding of what you're dealing with. Okay. So that was a lot of information, questions, confusions. Just going to pause for a few seconds here just to see if there's anything from that I can address or need to address. Oh, shoot, let me move this little bar because I think there are some messages in here that I'm not seeing. Can people on F1 OPT apply for an employment-based green card? Yeah, there is no, there is not a bar necessarily to applying for an employment-based green card. The thing is, again, what is going to hold you in the status? If F1 OPT is 1 year, this process takes 3. So what are you going to do after the F1 OPT 1 year if you're not even past the first step of the green card? And those are the things that you need to think about. We need to think about what is your foundation? What are your solid ground before you move into employment-based green card? And again, you have to look at the tree and not the forest. And every year is different. We just went through a significant economic, pandemic, whatever we want to call it. There are many US workers without a job. It is not going to be easy to go through, and frankly, right now, I can't even remember how many cases we have that we are actually going through this employment-based green card process. And we're very, very cautious, and we strategize with HR. What are you seeing? What kind of resumes are coming? And just so, because again, when we go through this process, that job that the foreign national has now, it's in the open. It's being advertised. And one of the places where it needs to be advertised is in the newspaper of higher circulation in the area. So some people do lose their jobs because of this process. So it's not something to jump into out of the blue, okay? Ellen is doing a great job kind of explaining what I'm talking about. Once an employment-based green card is issued, is this considered permanent residency? Yes. And actually, oh my gosh, I have to give kudos to this lady that just asked me that question, because she was also in our other webinar. I'm not going to say her name, but I adore her because she has really, really good questions. And just yesterday, so her question was, once an employment-based green card is issued, is this considered permanent residency? And yes, the answer to that is yes. When a green card is issued, that is considered permanent residency. So here's two things that I'm going to say, actually more than one, because of that question that she brought up, and it brings on a lot of other things in my mind. It is a very long process. There is a lot of commitment from the part of the employer to go through this in terms of time, energy, resources. And I am of the opinion, and every foreign national, every employer is open to do what they want to do, but many employers are reaching out to me and saying, well, okay, when they get a green card, can they just leave me after I, for the last 3 years, I've spent a lot of money in this process. And so that is, foreign nationals know that is kind of one of the things that you have to deal with. When you get at the end of this process, you will have a green card, you will have an open employment authorization document, and you can potentially leave your employer. Hopefully you won't, because they have put a lot of effort into supporting your goals. And this is a partnership. Many employers are reaching out to us for, working on a sponsorship agreements that the foreign nationals sign, saying, with this partnership, we're going to support your green card, but we also expect you to stay with us for 6 months, 3 months, a year, 2 years, whatever, after you get your green card. So, and I think that's fair. I signed one of those when I got my green card. But yesterday I was on a seminar, AILA, the American Immigration Lawyers Association, put that together. And I told my team, we all attend a lot of seminars, and some of them are like, I didn't learn anything. I hope at the end of this one, you're going to say, wow, I'm so glad that I attended. Because that's what I've been saying about the one that I attended yesterday. It was all about, the current trends on RFE from RFE's request for additional evidence. Anything from, they started on non-immigrant visas, so H-1Bs, and then they went into Perm, and the kind of request for additional evidence that we're getting from the Department of Labor. And they took it all the way into naturalization. It was fabulous. It was a really good overview. And guess what? Now the trend for naturalization, when clients get there, foreign nationals get to that stage, and they kind of say, oh my God, I just have to fill out a form. Yeah, it's 18 pages, but it's really simple, and there's a lot of resources out there. Well, know that when you apply for naturalization, your whole immigration history is in front of USCIS. And they are reviewing your whole immigration history. So the latest trend from my seminar yesterday is that they're issuing notice of intent to deny on naturalizations if the foreign national left their employment right after they got their green card. Because USCIS believes that they committed fraud, that they did not intend to be with that employer, and the only reason they were there is because they got a green card. So just food for thought. If you are going to go through a green card process and somehow or another you end up leaving your employer, it may come back around in 5 years from now when you go through a naturalization process if you go there. So just tidbits. Like I said, this just happened yesterday. Who knows what it's going to be 3 years from now, but that's where we are right now. Okay. What is the responsibility of the employee who now has a green card in regards to updating HR with current documentation, and how often? Well, so if they have a green card, I would think that if it is supported by the employer, I'm not sure that I'm getting the question, so I'm going to answer what I think. If it is a green card that they received through something else, for example, a marriage-based petition that you potentially didn't know, the employer didn't know because it happened through a marriage-based petition, then once they get their green card, they are supposed to update you and let you know that they received their green card, because otherwise, you would have had your I-9 would have showed you at some point that they were running out of work authorization. And another tip for green cards and EADs, and I'm not going to go into that because I really have a few other slides to cover here, but in general, once a foreign national gets a green card, a legal permanent residency, and that is verified, it's valid at the time of the I-9 verification, you do not have to verify it again. Okay. Okay, let me see. What determines whether or not an employee has to go through consular visa processing? Okay, so if this is in relation to the green card, a slide that I have in front of me right now. Good question. So most foreign nationals are in the United States when they go through the green card process. So we go through an adjustment of status, not consular processing. So the majority of my clients, I would probably say 80%, maybe more, are their adjustment of status. Some foreign nationals, and we've done a few of them, are not even in the United States through this whole process. They're abroad. So give you an example. I had a client from Spain. Well, my clients in the United States, actually in Jacksonville, they had a foreign national that had worked for them as a consultant from Spain for a number of years. And they had attempted to do the H-1B visa. He was still abroad, filed the H-1B visa, didn't get selected, He continued to work from abroad as a consultant, came into the United States every so often on an ESTA, went back. So they reached out to me and said, we really, really want this guy. He had a lot of experience. We don't want to bother with the H-1B visa process anymore. And he doesn't care to come here until he gets his green card. He wants to bring his family. Can we do this process? And he can, continue to support us remotely as he has been. So we did. So this is one of those people. He never came. Well, I mean, he was not here for none of this. We did the Perm, we did the I-140, and then we noted in the I-140 that he was going to consular process his green card. So he went through Madrid and got his green card in Madrid, entered the United States with a green card. That would be one of those situations where the person consular process. Last year, before the pandemic, where there were significant delays, and actually this was even frankly before the pandemic, and then the pandemic messed everything up. There were a lot of delays in consular processing and other things, and we had some clients from Canada, and the consular processing of the green card was much faster than waiting for the adjustment of status. So we noted in the I-140 that they will consular process when the I-140 was approved. A caveat to that is that the person is, they're in the United States, and then when they get the consular appointment, they go out and they come back and they enter. So hopefully that explains it. The majority of the times when consular processing is issued in this process is, again, it's like the example that I just gave you for my client in Spain. Okay. To determine where, okay, so Ellen answers something there, so I'm going to move on. Does the green card have to be updated every 10 years? Yes. The foreign national is related. Okay, so Ellen, thank you so much. I'm going to move on to my slides. Okay. So done with the employment base, green card. The next one that I'm going to tackle is working overseas. Again, this doesn't apply to everybody. It has to be if your company has an office abroad, or that you can transfer that foreign national to work at. And like I said, we have quite a few of our clients that are global employers. Quite a few of you are on the call today. So this is an option, and I'm going to be exploring this option with you when we get on the phone for each one of the individual cases. The situation here would be that you have an office abroad that has a need for the skills that the foreign national brings to the table. The foreign national is willing and able to move abroad. Hey, a paid vacation to someplace fun in the world. I don't know, hopefully. So you go there. And I think actually if I was young and unattached, and that this may not be a bad idea, but so what happens is for the intra-company transferee, the things that need to be in place are the main things that need to be in place. And that's kind of what is depicted here in the pictures. Obviously, you have to have an office in the United States and an office abroad that are related, and that relationship is evidence. It's part of the evidence in the petition, whether they're a branch, whether they're an affiliate, whatever it is, but the relationship between those two companies needs to be there. So relationship between the companies, qualifying relationship, qualifying employment abroad. This is important. So that position abroad is not just any position. There is one level where it's a manager or an executive, and obviously that may not work for many of you. And then the other one is in a specialized knowledge position. So that person goes and either brings to the foreign company or brings back to the United States, and ideally brings back to the United States some unique process, some unique system, some unique something that, and that is part of the reason why they go there, is to acquire that knowledge so they can bring it back to the United States as a specialized knowledge so that their US operations could benefit from that. So qualifying relationship, qualifying position, and then to some degree that position abroad, and that's what I have this chart here. Ideally, if they're they have to be in some sort of a higher level position. It shouldn't be an entry level position abroad. That would not make for a good L. Okay. So this requires some, and for example, I'm going to give you an example of a client right now that also he has an advanced knowledge, had been working abroad in the UK, I believe, and then he was assigned to the Philippines and worked there for a little while. And we were exploring options, and he was going to be assigned to the Philippines or somewhere in Asia for at least a year. And so we looked at both. We looked at the H-1B lottery and the H-1 and the L. And again, because the H-1B is a lottery, I said to our client HR, let's put him through the lottery, because it's just, if he gets the H, it is simpler than doing an L. And he can come into the United States and really, again, because it's a lottery, I wasn't really sure that he was going to get selected, just like we don't know who's going to get selected, but he did. He got selected last year. And so he's on an H, or he will be in an H. Now, he has been barred from entering the United States, as some of you may know, that the travel ban for H-1Bs and Ls and whatever just went away with a lot of fanfare, interestingly. It just kind of dissipated. The Biden administration they just let it dissolve. So it's gone. Now the bigger issue of getting those people back into the United States is not so much the travel ban. Now that's gone. It's the fact that many consulates are still not fully operational. And we also have COVID-related bans in various places that is making it hard for people to come back. But for this particular foreign national, if he would not have been selected on the DH, the L1 was already a planned path for him, and that would have worked just fine. Okay, I'm going to go through this very quickly because someone asked about the O1, and this is for many of you that are in F1 status, the O1 is way out there. The O1 is an extraordinary ability. It has a lot of requirements. In fact, just a few days ago, USCIS issued an update as to, what does it mean to be extraordinary and what kind of evidence. So kind of let me give you an example. One of the examples that came up was like, okay, so I'm a marathoner, the Boston Marathon, obviously many of you know. There's elite runners, and there is people like me that are not elite runners, but we run the Boston Marathon. So that was an example that they say, okay, for an O1, it's not that you qualify to run the Boston Marathon, or me. I'm not an elite runner, so I could not use that as an evidence for my extraordinary ability. But if I was one of those elite runners from whatever, Africa somewhere, with Kenyans and whatnot, that I can use as an evidence for the fact that, I'm extraordinary. So look at it that way. It's a very, very high standard. Not to say I love O1s. We do a lot of O1s because we're working with the top of the field. So this is a visa that I'm passionate about, but it's not for everybody. Okay, returning home. For some, this is going to be the option, okay? So what happens? After your status ends, 60 days grace period. So all of you that are on F1, so whether F1, OPT, F1 STEM, you do have a 60 days grace period. During that grace period, you're not authorized to work, but there's various things that you can do. Explore options. What else is there? You can travel in the United States, I'm sorry. You can change your status to something else. If, again, each one is going to be specific to you. You can continue your F1. You can go back to school. That is always an option on the table. Okay, so don't take that away. And, you could prepare to go home. And last year, some people did go home. Most of our clients somehow, after the calls and the strategies, everybody figure out something that they were at peace with. For you on F1 status, please keep your DSO updated, because your service records is what tells USCIS and what you're doing. So you don't want your service records to close or be inaccurate, and they may think that you're accruing a lawful presence or anything like that. So whatever your decisions are, share it with your DSO. And also know that if you do leave the US during this grace period, so say it's, day 25 of my grace period, and I decided, I want to take a trip to Canada. That may be last time that I could see Niagara Falls so quickly, whatever. You may not be able to come back to the United States. So I would say use those 60 days wisely if that is what you're going to do. And next, a slide that my team said to me, why don't you put this slide up towards the top? And I'm like, because it's another lottery. And will there be a second lottery this year? Potentially. And the reason I think that is because, at least in general, from the immigration attorneys, business immigration attorneys, the general consensus is that we have seen the lowest percentage of selection this year than ever. And some of the speculations as to why that happens or that happened is because some foreign nationals, and again, this is speculation and who knows, but the speculation is that some foreign nationals paid or were able to get their names added to the lottery several times through various employers. So if you remember, there is a penalty in the process, in the current process. So Mark Gray, as an employer, could not enter Ellen in the lottery 3 times. That would basically disqualify Ellen altogether. So not even one of those chances she would have. If USCIS sees her name there twice from Mark Gray, she's out. And there are several cases out there that have been denied, that have been rejected, But it's not a penalty if Mark Gray petitions for Ellen, if, who knows, another law firm petitions for Ellen, and another law firm petitions for Ellen. So Ellen could be wonderful and have lots of friends and relationships, and 10 people could have petitioned for Ellen. Again, I have no idea that this is, not that I have no idea, but this is speculation, but something happened it appears that several foreign nationals were in the lottery in various ways somehow. And that has decreased the number of applicants or the percentage in the total lottery. At the end of the day, I think this is going to come to bite some people, and it's just not going to work out when you push the limits like that. It's just not right. It's not what we stand for. But at the end of the day, if that is true, they cannot work 10 jobs. They cannot work 5 jobs. That's not going to happen. So it is, again, the belief that there's going to be some petitions that were granted or that registrations that were granted that will not be able to be used because some foreign nationals are not going to be able to work various jobs. If that is the case, there could be a second lottery, and that would be at the end of the current lottery. So somewhere around August of this year. Now, know that last year we did have a second lottery, and at that point, it was because of the economy. Many foreign nationals that were selected, um, the business necessity was not there, the petitions did not go through, were not filed, and those visas were there and they were reissued. Interestingly, though, there was almost no notice whatsoever. I basically got an email, and my clients got an email, my HRs got an email saying, oh, there has been a movement on your case. It's something very, very blurry that you were like, huh? And yeah, we didn't have a lottery. There was no notice. There wasn't much going on. But if there is one, it will be in August. But the reason I put the slide here is because, yeah, there is a potential, but please, 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 for all of you out there, this is why I did this. And this is why I put it here and not at the front, because it is very tempting to hang on to this. And again, this is another lottery. We need to look at all the other options that we talked about, and maybe some more that I haven't even thought about, but it could apply to you. And we have to pursue those. And if you get selected on the second lottery, hey, that's wonderful. But I don't want any of you to count on this as the option for your future, okay? I'm heading towards the end here. I've mentioned I'm a runner, and again, there is a lot of information out there. Please, and I constantly get emails just saying, I read this, I read that, I heard this, my friend that. And I always say, you know, and again, those of you that are my clients, I say to you, every case is unique, every case specific. Immigration is so fact specific. I want to see the documents. I want to see exactly what happened to your friend, because it's never the same. And again, our job, as much as we can, is to give you peace of mind, is to give you education, to give you practical options. I don't put out there a whole bunch of potential things that at the end of, because I know you have a lot to worry about. So do take it with a grain of salt. Don't take everything as truth that you read online. It is very, very stressful. I get it. Just caution, okay? Let me just see here. What if an employee F1 expires in July and she was not selected for the third time, blah, blah, blah. I know she cannot work after her expiration day. What happens if she is selected in the second lottery during her 60 days? Well, if she is selected during her 60 days, then, you know, she's selected. I would, so what happens, I mean, I don't know, again, if this is the questions you're asking. And I did a presentation just last Tuesday about what happens to those that are selected. So for some of you, I know that presentation is important and you were not able to attend, so I will make sure that you get it. But there is a process. Even if you get selected, you're going to have a notification or a registration notice that you were selected, blah, blah, blah. You have 60 days, 90 days. You have 90 days to file. And then, so that process needs to begin and be filed within 90 days. If this is, and again, I would not bank on this 60-day, on this other lottery, but it is a potential and you would need to be very ready to file if that's what happened, okay? I'm coming right to the end here. I hope, again, that this was very helpful for some of you. Again, I hope you have the feeling like I did yesterday that this was, you should have been here, and what you received was helpful to you and gives you peace of mind. Some of you know I wrote this book, Beyond the H-1B, and we did it, and my team here helped me edit and read all this for over a year. And I did it because of the passion that we have. I'm an immigrant myself. I love what I do. I've been doing it for a number of years, and I want nothing more than to help you employers hire people like me and for you foreign nationals, you know, have your dreams come true. I think this is an amazing country, and this is what we do. So it is pleasure. It is an honor to work with all of you. I look forward to continue to be sharing our passion and our energy so we can help you achieve your goals. I will be talking, Tyra, Ellen, and I will be talking to you soon to explore your particular options. I hope this was helpful. Again, I thank you so much for being here with me. I know these are stressful times, and again, I hope this was helpful. So thank you so much. Talk soon.